10:02, so I think we are good to go ahead and get started. So I'm very happy to see so many people who have joined us here this morning. So this is a town hall on Senate Bill 1433, just recently chaptered. Senate Bill 1433 from Senator Roth was the Bureau's sunset review bill this year. In addition to extending the sunset date for the Bureau, the bill also makes numerous changes to the California Private Postsecondary Education Act. So as I mentioned, the bill has been chaptered and becomes effective January 1, 2023. So I know as far as the Bureau meetings are concerned, this is the first time we're doing a town hall like this event for this bill. Though I know we've discussed the bill and the major provisions of it at several of its advisory committee meetings, for those of you who follow that. At our most recent meeting earlier this month, we flagged some of the provisions that we anticipate needing regulations for. So that might be something good to go back and look at if you haven't seen that yet. But we do know that the extent to which stakeholders are following these meetings of ours or the legislative process varies quite a bit. So the purpose of this town hall is to raise awareness of the provisions of the bill for stakeholders and to hear the questions that you might have about implementation. So the feedback that we received today will inform the guidance that the Bureau subsequently releases. So just to reiterate that point, our goal today is not to answer all the questions or have all the answers ready to share with you today, but to hear what your questions are so that we can provide appropriate responses in writing to you in the coming weeks. So in terms of the structure of this meeting, David Dumble, who is the Bureau's Legislation and Regulation Manager, will be walking through each of the provisions of the bill with frequent pauses to solicit questions or comments about what would be helpful to see from the Bureau in terms of guidance. He's not going to pause after every single issue because there's a number of them, but there will be frequent pauses. So if he doesn't stop right after an issue you want to raise a point on, don't worry, the break will be coming up quickly enough. When we get to those breaks, we'll also have instructions on how to raise your hand or submit a comment. And with that, I will turn it over to David Dumble.
Thank you, Debbie. As she said, I'm David Dumble. I'm the Legislation and Regulation Manager for the Bureau. And I'm going to be going through all the provisions of SB 1433. Not every provision applies to every institution. So if you think something that may not apply to you, chances are it does not. I may sound like I'm speaking a little rapidly, but we have lots of time. So if I go past something that you had a comment on, as Debbie said, we'll have frequent breaks and pauses. So keep your question or comment in mind and we can come back to it. Can we go to the first slide or next slide? The first section of SB 1433 deals with out-of-state school registration. And the primary purpose of this first aspect of amending 94801.5 is to allow out-of-state unaccredited schools to register to enroll California residents. This is a largely technical change, and we've already taken steps to implement this. Our current regulatory package on out-of-state regulation is in the 45-day comment period, and in that package, we added the words "as applicable" to the registration form. And by adding this will allow unaccredited out-of-state schools to register. The second technical change that was also in this section, it allows out-of-state, low-cost, non-degree granting institutions to be exempt from registration requirements. And this simply mirrors the exemption for in-state low-cost non-degree granting institutions that is provided by Ed Code 94874F. So can we go to the next slide? Continuing on with changes to out-of-state registration, Section 2 of SB 1433 establishes a new section called 94801.7. And this is an area where we think the Bureau will have to provide regulations. It allows the Bureau to establish thresholds for establishing when out-of-state institutions have limited physical presence in the state, and it defines physical presence as offering instruction or core academic support services in California. These terms need further refinement, and that's why we think we're going to have to provide regulations to come up with a definition for physical presence and for academic support services. This section of the bill also clarifies that all institutions operating in the state and subject to either approval or registration, in-state schools are subject to approval, out-of-state schools are subject to registration. All schools operating in the state shall comply with section 94897, which is the prohibited business practices section, and we'll be coming back to that later in the presentation. Given the importance and complexity of these definitions, we anticipate having further public discussions, most likely at upcoming advisory committee meetings, before pursuing any regulatory proposals on defining physical presence and core academic support services. Next slide. And this sort of piggybacks onto previously I mentioned operating in the state. This is an amendment to section Ed Code section 94869, which is the definition of to operate, and it merely expands the definition to include out-of-state institutions enrolling California residents via distance education. This is a largely technical change. It just clarifies what it means when we say an institution is operating in California. Next slide. At this point, we'd like to break for public comment.
This is the moderator. I am opening up the Q&A. It is now open. The instructions are on the screen for your reference. Members of the public, if you would like to participate, click on the question mark inside of the square, which is typically located at the lower right corner of your WebEx screen, and type in the word comment and make sure that goes out to all panelists before you hit the send button. You can also raise your hand by hovering your cursor or mouse over your name, which is found in the participant panel, and an outline of a hand will appear. Click on that outline of a hand to raise your hand. And those who are calling in, you can raise your virtual hand by pressing *3 from your phone. So I'll give it a moment to see if there are any requests coming in. I do have individual Roxana Sanchez. I will find your microphone so we can unmute that. Okay, sent a request to unmute your phone.
Hello? Hello, can you hear me?
We can hear you.
Okay. I have a question. So this new, I will say service, can California schools provide the same service to other areas in California currently? The distance.
And my understanding of the question is may California institutions based in California enroll students online from other states?
My question.
And there's no changes related to that in this law.
Oh, okay. But can California schools provide the service to other states? Because it seems like the schools from other states can recruit students from California. Can California schools recruit students from other states?
Yes, they can. And in fact, I mentioned the provision about giving an exemption to out-of-state low-cost non-degree granting institutions. That provision is to keep in with the Federal Interstate Commerce Clause, which says we cannot exclude businesses from other states from operating in California, and conversely, other states cannot prevent California businesses from offering services to their residents. So yes, California schools can provide distance education to residents in other states.
And this distance education includes just theory, or it also can include practical?
So I could make a recommendation, just back to the earlier comment about, we're really looking to get feedback on what to put in our guidance. This is a very helpful question, and we will definitely make sure that we speak to that. If you are able to send a note at the very last slide, I'll kind of preempt the very last slide here, is that we're going to be offering people who have additional comments or questions that weren't raised in the meeting today, a chance to email those comments or questions into us, and that's just to our general email inbox. It's bppe@dca.ca.gov. If you, I would encourage this questioner to send a very specific question. If there's this type of scenario, it sounds like you have in mind, and we'll just make sure we can cover that in whatever we have coming out in the coming weeks. And the other thing I would just say, and I want to be very clear on this when we talk about other states, what we're talking about here is California law, and of course we can't speak to what other states require of institutions enrolling their own residents.
All right, thank you.
Thank you.
This is the moderator. And the next individual, Steve Watkins, I'm going to send a request to unmute your microphone. Microphone and
Hello?
yes, we can hear you.
Hi. Yeah, my question is, I know the language is going to be refined before the new law would take place, but what's the sense of the physical presence definition applying to an out-of-state, non-California school who whose only activity in the state of California would be to oversee or manage externship or clinical site training, let's say at hospitals in California or medical centers, without actually having a physical campus location in California? Would that trigger a physical presence?
As I said, at this point, we know we're going to have to develop regulations to refine these definitions. But at this point, we have not started the process of actually working through what we need, which is why we're having this town hall meeting, to get feedback from people as to what might be necessary in developing these regulations. And it's going to be very complicated, and we'll certainly revisit this most probably at future advisory committee meetings. But if you have any input, as Debbie was saying to the last speaker, feel free to email any comments to us at our email address that will be given at the end of the presentation, and we would appreciate any feedback you have.
Perfect, thanks.
This is the moderator. I'm going to send a request to unmute Kelly's microphone. Give me just a moment as I locate that microphone. Request has been sent. And I can read the message here. The question was if it would be provided as an attachment. I'm sending a request to unmute the microphone, but it's not being accepted. I'm assuming there's no further comment.
Slide with the definitions will be provided.
Thank you. Moving on to the next individual, Ariel. I'm going to send a request to unmute your microphone.
That has been approved to operate as a non-accredited institution, but we have a sister organization in Illinois, which is a Title IV educational entity. Would we need to get them approved through your BPPE regulations, or would this be something easier that we would be able to bring those services into this state for this discussion?
It sounds like a specific question. I'm not sure that I'm not sure I'm understanding the nuances. But so again, I would encourage you to email us at bppe@dca.ca.gov with your specific situation, so we can get you the guidance you need.
Next individual, Rachel, I'm going to send a request to unmute your microphone. Request has been sent.
And that, just like you said, she needs to check with the other states.
Okay. Next individual, Andrew, I'm going to send a request to. Okay, Andrew probably doesn't have a request. It's pointing out Debbie's microphone coming in fuzzy and distorted. Thank you for the feedback. And Kim, I'm going to send a request to unmute your microphone. Request has been.
Thank you very much for this meeting. Will an application be available sometime between now or around the 1st to apply as an out-of-state unaccredited, or will we wait till the regulations are defined? School should submit.
You're asking if an unaccredited, when unaccredited school, out-of-state schools can start the application process?
Yes.
Yeah. The statute will go into effect on January 1st, but the regulations, as I said, they're currently in the 45-day comment period that will end on December 27th. We'll then submit them to the Office of Administrative Law, which will take approximately 30 days to either approve or deny them. Assuming they're approved, we are going to include a request that those regulations go into effect upon filing. So they could be in effect sometime in January, but if not, then they would go into effect on April 1st.
So no application is required as of the effective date of the law until the regulations are finalized.
We will have the new application when it is approved by the Office of Administrative Law.
Okay.
And that will be sometime after the 1st, but we're not sure exactly when.
Thank you very much.
This question of the timing of this is certainly very much on our radar, so we will make sure that that is covered in forthcoming guidance.
No further requests have been submitted. Would you like me to close the Q&A feature?
Yes, please. Thank you.
Okay, and if we can move on to the next slide. The next two sections deal with the situation of schools losing their accreditation. Existing law requires unaccredited degree granting institutions to obtain accreditation within timelines established by the legislature. However, the law has been silent on what happens if an institution loses accreditation, either because their accrediting agency loses recognition from the U.S. Department of Education, or because the institution itself loses accreditation. SB 1433 fills both of these gaps by aligning the existing requirements for unaccredited degree granting institutions and applying them to schools that lose accreditation. The first situation is in Section 4. It's where the accreditor loses recognition from the U.S. Department of Education. If that happens, the institution shall submit an application for an approval to operate as an unaccredited institution within 6 months. The application must include a plan for the institution to be reaccredited within 5 years, and the Bureau will have 18 months to approve and issue a provisional approval to operate or deny the application. A denial results in the institution having no approval to operate. If the institution fails to submit an application for approval to operate within 6 months, it means the institution will cease to be approved to operate. And lastly, if the institution an institution shall not seek approval for any additional degree programs until it is reaccredited. Next slide. Section 5 deals with the situation where an institution loses accreditation. This is Ed Code 94885.7. If an institution offering at least one degree program ceases to be accredited, then it shall notify the Bureau immediately or within 7 days. And then at that point, the approval to operate the degree programs becomes provisional. Institutions with provisionally approved degree programs must first not seek Bureau approval for any additional degree programs. Secondly, they must submit a plan for becoming reaccredited within 5 years, within 6 months of the degree programs becoming provisionally approved. And let me just reorganize that. Within 6 months of becoming provisionally approved, the school must submit a plan for becoming reaccredited within 5 years. And then thirdly, the institution must submit any additional documentation the Bureau deems necessary to determine if the institution is making progress to becoming reaccredited within 5 years. Next slide, please. Additionally, institutions seeking reaccreditation must notify in writing students seeking to enroll that the institution is approved to operate a degree program and that its approval is contingent upon being reaccredited. And within 2 years of becoming provisional, the Bureau will review the institution's progress toward reaccreditation. Any institution not complying with these requirements will have its provisional approval automatically suspended. An institution may choose not to seek reaccreditation. Upon the Bureau's receipt of this notice, the institution's approval is deemed voluntarily surrendered. Next slide. Did we want to stop for public comment there?
This is the moderator. I'm opening up the Q&A. It is now open. The instructions are on the screen for your reference. Members of the public, if you would like to participate, click on the question mark inside the square, type comment in the text field, and make sure that goes to all panelists before you hit send. If you prefer, you can raise your hand by hovering your cursor or mouse over your name in the participants panel. And once that outline of a hand appears, make sure you click on it to raise your hand. For those who are calling in, if you would like to participate, you can raise your virtual hand by pressing *3 on your phone. I'll wait a couple seconds here to see if there's any requests coming in.
Thank you. While we're waiting for requests to come in, first I'll say I'm trying to change some settings in the audio so folks can let me know if this is better or worse or the same. But I would also, just as folks are processing those last two sections, just highlight that those are really very existing sections in the law that have been in the law for many years. They're really about solving for gaps about what happens when an institution loses accreditation. So it borrowed heavily from other sections that have been in the law for, like I said, many years and already been running. So they sound really confusing, but that's how they came to be.
And Debbie, the quality was pretty bad actually. On your mute unmute button, so right now it's your mute button, there's that little down facing arrow. If you click on it, it will a menu will pop up and you'll have speakers, microphone, WebEx Smart Audio. You'll have those options. So under the microphone option, try to click on any other option. There's a check mark next to the microphone that you're currently using. Click on the other option.
Okay, well, I went ahead and did that, and I basically reverted back to how it was previously. Is this better?
Oh yes, you're clear.
Okay, great.
Thank you. The only request that we received, Claudia, let me go unmute your microphone. Give me just a moment. I sent a request to unmute your microphone. And Claudia, you were unmuted. We only heard some static. I see that the question inside the Q&A was, can the 5 years be extended? I'm going to send a request again to see if we can make that work. Claudia, we can hear your microphone's unmuted. There seems to be technical difficulty from Claudia's microphone, but the message was left in the Q&A that says, can the 5 years be extended? And that's all the requests we have. Would you like me to close the Q&A feature?
Yes, please do. And I will respond that the law does provide some allowances for extensions in certain circumstances. So I will say there was also a question I believe I saw in the chat about whether the slides will be shared. I believe they will be part of certainly the webinar that will then that's being recorded now and posted on our website. But really would want to underscore most of all that folks go look at the bill language itself. There's really nothing in the slides that was not taken straight from the statute. So encourage everyone to go look at Senate Bill 1433 for all the information.
Okay, if we can go to the next slide. This is another area where the Bureau anticipates promulgating regulations, although again, we have not started that process, but we know regulations will be needed. This deals with Education Code 94887, which specifies that the Bureau may deny an application for approval to operate institutions that would be owned by, have persons in control of, or employ institution managers that had knowledge of, should have known, or knowingly participated in any conduct that was the cause for a revocation or unmitigated discipline at another institution. And just to be clear, the terms person in control and institution manager are already defined in Ed Code sections 94845 and 94856. And this basically is our attempt to deal with a situation where individuals will operate at a school, they will commit violations, and then the school closes, and then they move on to another school. And so this is a statutory attempt to try to avoid that situation. And again, we know we are going to have to come up with some definitions to implement this, but we have not started that process at this time. Next slide. This is a somewhat related proposal or implementation. The substantive change law currently requires school institutions to give us notice if there is a change in ownership. This expands that definition to be a substantive change if it's a change in ownership or a change in person in control. And again, person in control is defined by Education Code 94856 as a person who, by his or her position's authority or conduct, directs the management of an institution. And the Bureau is again considering through regulations whether we need greater specificity of the definition of what it means to be a person in control. Next slide, and we're up to another public comment break.
This is the moderator. The Q&A is now open. The instructions are on the screen. If you would like to participate, click on the question mark, type comment in the text field, and send that to all panelists, or hover your mouse or cursor over your name and click on the hand outline that will appear. Those calling in, press *3 if you would like to participate. No request at this time. Would you like me to close the Q&A feature?
Yes, please. The next slide, I said we'd get back to prohibited business practices, and we are back at it in Section 8. The SB 1433 adds 5 new practices that are prohibited. The first is an institution may not in any manner commit fraud against or make an untrue, misleading statement to a student or prospective student under the institution's authority or the pretense or appearance of the institution's authority. Secondly, an institution may not charge or collect any payment for institutional charges that are not authorized by an executed enrollment agreement. Thirdly, an institution may not violate Section 1788.93 of the Civil Code. And if you're unfamiliar with that code section, it prohibits schools from withholding or threatening to withhold a transcript as a means of collecting a student debt. The next prohibited business practice is requiring a prospective, current, or former student or employee to sign a non-disclosure agreement pertaining to their relationship to or experience with the institution, except that an institution may use a non-disclosure agreement to protect the institution's intellectual property and trade secrets. Any non-disclosure agreement in violation of this section is void and not enforceable in law or equity. And lastly, institutions may not fail to maintain policies related to compliance with this chapter or adhere to the institution's stated policies. Next slide.
Dave, if I could just pause real quick on this one, if we could just head back to that last slide just quickly. I just see that we have one typo that is in here for Q right there, 94897Q, the first one on this slide. It's missing a word. It is actually the word material is missing from this version. So it should read, in any manner commit fraud against or make a material, untrue, or misleading statement to. So just wanted to make that make sure that that was part of this discussion.
Thank you. Are there any comments or questions?
This is the moderator. The Q&A is being open. The instructions are on the screen for your reference. If you would like to participate, click on that question mark, type comments, send it to all panelists, or raise your hand by clicking on the outline of a hand that pops up. Once you hover the mouse or cursor over your name, or those calling in, just press *3 to raise your hand. I see no requests coming in. Would you like me to close the Q&A feature?
Yes, please. Moving on, Section 9 of the bill establishes in Ed Code 94899 that an institution offering an educational program requiring approval from another licensing agency in the state, for example, barbering and cosmetology, Bureau for Auto Repair, if approval from another licensing agency is required and the institution loses that approval, they shall have their approval to operate that program automatically suspended by the Bureau by operation of law. The institution is required to notify the Bureau within 10 days of the loss of approval to offer the educational program and shall cease offering the program within 30 days unless an earlier date is required by the licensing agency. And approval to operate the educational program will be reinstated when the Bureau is provided proof of proper approval and proof that the program is in compliance with all Bureau requirements, in addition to the requirements of the licensing agency. Next slide, please. This is a requirement that all catalogs contain a notice regarding the Office of Student Assistance and Relief. All catalogs must have the verbatim language that is printed here. The Office of Student Assistance and Relief is available to support prospective students, current students, or past students of private post-secondary education institutions in making informed decisions, understanding their rights, and navigating available services and relief options. The office may be reached by calling, insert toll-free number here, which is currently 888-370-7589, option number 5, or visiting the internet website, which is osar.bppe.ca.gov. Next slide. This deals with the enforceability of loans. It clarifies that a note, instrument, or other evidence of indebtedness is not enforceable and is void unless at the time of the execution, the institution had approval to operate. It also clarifies that institutions, out-of-state institutions that have a valid registration are considered the same as approved to operate. So in order for an instrument of indebtedness to be valid, you either have to be, if you're an in-state institution, you have to be approved to operate, or if you're an out-of-state institution, you have to have a valid out-of-state registration. Next. And in keeping with the topic of student debt, Section 12 largely deals with the Department of Financial Protection and Innovation. This is a relatively new state department that was created within the past 10 years. And the provisions basically clarify that nothing the Bureau does or any authority the Bureau has is intended to interfere with the operation of the Department of Financial Protection and Innovation's authority or jurisdiction over financial products and services. So nothing in the Bureau's administration of Article 13, which deals with consumer loans to students, or Article 13, which deals with cancellations, withdrawals, and refunds, shall preclude the authority of the Department of Financial Protection and Innovation over anyone defined as a covered person in Section 90005F of the Financial Code. Nothing in the Private Postsecondary Education Act constitutes regulation of an institution's financial product or services under Section 90009A to B of the Financial Code, or it limits the authority of the DFPI's jurisdiction over an institution's financial product or services. And lastly, it establishes that an institution subject to the Bureau's oversight is not acting under the authority of its status with the Bureau when offering financial products or services. And with that, we can go to the next slide and have another break for comments or questions.
This is the moderator. The Q&A is now open. Instructions are on the screen for your reference. If you would like to participate, click on that question mark, type comment in the text field, and make sure you hit send. Raise your hand by hovering the cursor mouse over your name and clicking on the outline of a hand that appears. Or for those who are calling in, press *3 to raise your hand. No requests. Would you like me to close the Q&A feature?
Yes, please. Moving on to Section 13. This is another area where the Bureau anticipates regulations will be needed to implement this. It establishes that if an institution's approval to operate is automatically terminated on the date of closure or when its exemption from this chapter has been verified by the Bureau, if the institution does not identify a date of closure, it shall have one selected by the Bureau, and a terminated license shall not be reinstated. This will need regulations to determine the methodology the Bureau will use to identify a date of closure if one is not selected by the institution. Next slide. These two sections 14 and 17 deal with some provisions that were first adopted in SB 802 in 2021, which allowed the Bureau to act in cases of potential student harm to protect students from harm occurring. Section 14 says the power of the Bureau to impose penalties for noncompliance. It is expanded to permit consideration not only of harm to students, but harm that may have resulted to students. So if you did something that potentially could have harmed a great many students, but for some reason you got lucky and only a few students were harmed, the Bureau can take into account that much greater harm might have occurred had circumstances be different in considering the penalties. Similarly, Section 17 permits citation for violations of the Act for failure to comply with a notice to comply to factor in not only compensating students for harm that actually resulted, but also for harm that may have resulted to students. So again, this is factoring in potential harm in addition to actual harm that occurred to students. Next slide. Ed Code Section 94934.5 now requires that reports of investigations by oversight entities be reported to the Bureau in writing, and it expands the definition of an oversight entity to include any governmental agency. Next slide. And we're ready for another more comments or questions.
This is the moderator. The Q&A is being open. The instructions are on the screen. The Q&A is now open. If you would like to participate, click on the question mark inside of a square, type comment, and send it to all panelists. You can raise your hand by hovering the cursor mouse over your name on the participant panel and clicking on the outline of the hand, or pressing *3 if you're calling in. I do have individual raising hands. Scott, I will send a request to mute your microphone, and I will then address the request in the Q&A.
Am I up?
We can hear you.
Okay, thank you. Regarding 94933, is the Bureau going to develop some regulations? How do you determine what potential harm is, or what quantify the value of that?
I will say, this is not one of the provisions that we have identified as needing regulations at this point. It's certainly something that we will take a look at, and we'll also see if there's something that we can put out that kind of sort of, I think, puts a little bit of more of a tangible point on some of this language in forthcoming guidance.
Perfect. Thank you.
Thank you. I'm going to send a request to unmute Barney's. Give me just a moment. Microphone. Give me just a moment as I locate that microphone. Request has been sent. Oh, the question has been answered. Thank you, Barney.
Answered.
No further requests. Would you like me to close the Q&A?
Yes, please.
Thank you.
This next section deals with remote inspections, and here I actually wanted to show the language that was being changed in the statute, just to show what a small change is being made and not any sort of significant change in philosophy. During COVID, the issue came up whether the Bureau could do inspections remotely, and it was determined that the Bureau could not because of the 4 words in red in the statute that said, a notice to comply shall be issued before leaving the institution. And this was determined that meant that all inspections had to be on site. And so SB 1433 deletes the words before leaving the institution and replaces them with at the conclusion of the inspection. Once this is implemented, the Bureau will be able to do remote inspections. This does not mean we intend to start doing primarily remote inspections or have any change in how inspections operate. We just, the language was changed just to give us the option of doing remote inspections if that is a useful option for us to have. That's why that small change was made. And now once this is implemented, we will be able to do remote inspections. Next slide. This clarifies in Ed Code 94944, the maximum fine for operating without a license is $100,000. And this clarifies that that is not inclusive of fines for other violations or refunds ordered. So if you are found to be operating without proper approval, you may be fined $100,000, and you will then also be fined additionally for any other violations or refunds ordered. Next slide. Section 19 gives the Bureau the authority to give approval to operate to public institutions from other states that have a physical presence in California. The Bureau will administer and enforce the terms of the Private Postsecondary Education Act in the same manner as with private postsecondary institutions, and public institutions shall comply with all laws and regulations, including those relating to fees, annual reports, compliance inspections, and STRIF, although their compliance will be about the physical institution in California and not for the institution as a whole. Next slide. Lastly, and most importantly, SB 1433 extends the Bureau sunset date to January 1st, 2027. So we will have 4 more years until we have to go through another sunset hearing and procedure. And with that, that is the provisions of SB 1433. Are there any comments or questions?
This is the moderator. The Q&A is now open. The instructions are on the screen. Click on that question mark inside of the square, type comment, and send it to all panelists. Or hover your mouse or cursor over your name and press on the outline of a hand that appears. For those calling in, *3 to raise your hand. I see no requests. I do see congratulations on the new sunset date. Would you like me to close the Q&A feature?
Yes, please.
Okay, thanks.
And as we said before, if you have any comments or questions or anything occurs to you after the conclusion of this town hall, please feel free to email us at the general BPPE email address, which is bppe@dca.ca.gov.
Thank you so much, Dave, and for all of you for joining us this morning. Just one kind request: if you do email us with future comments or questions, and again, we encourage you to do that, it would be helpful if you put in the subject line SB 1433 Town Hall. That will just make sure that we can route that question to Dave and myself, and we can make sure we're getting it's getting to the right place. Also, I know that some questions did come up about specific institution status or things that really apply specifically to them. Certainly also encourage you to reach out to the Bureau with those questions. We'll again route that to licensing or administration or wherever it needs to go. But certainly we're here to help answer your questions, whether it's about this law or longstanding law. So thank you again to Dave. Thank you for all of us for joining us, and thank you to the moderators for helping us move through this meaty law so efficiently. Only 48 minutes in. Enjoy the rest of your week, everyone.